Welcome back to this course on copyright and related rights law. In this week, we are discussing a foundational requirement for subsistence of copyright: originality. In the previous sessions, we have looked at certain important considerations which must be kept in mind before we look at the construction of originality by courts themselves. We have understood that a conventional understanding of originality focuses on the mere consideration that there must not be any copying. But is there anything more that we must consider, and what is the threshold of that consideration? This discussion on originality and its construction by courts is split into two parts. In the first part today, we will look at mostly cases that are focused on a conventional understanding of originality, ending this particular session with one of the most important cases in the evolution of originality in copyright law, a case decided by the US Supreme Court in Feist versus Rural. In the next session, we will carry forward that discussion and see how the Feist decision has influenced originality construction in other courts in different parts of the world, including in India. Having said so, the Indian Supreme Court decision in Eastern Book versus D.B. Modak is a seminal case that we will be focusing on, and in fact, the exposition by the Supreme Court of the evolution of originality is something that I have taken extracts from and will be attempting to explain in a simple fashion. Let us first keep in our mind that we were trying to understand on what threshold consideration would copyright subsist in a work. Therefore, if it is a literary expression or an artistic expression, is it the effort expended in creating that expression? Is that the sole consideration for the grant of copyright? You can see in this image, this person has possibly taken some effort for some activity, and he's perspiring on account of this activity. The doctrine of sweat of brow is connected to the expenditure of effort. It has biblical roots, in effect meaning that if a person has expended an effort in doing something, in laboring for it, then the value of that particular labor is for him to exploit. This particular application of sweat of brow has certain issues. For instance, if effort was the sole consideration for grant of copyright, then independence of copyright, then independence of creation, and the consideration that a work has not been copied from another work would be enough to satisfy the grant of copyright, because an effort, no matter how minimal, would be expended by a person in creating what he has created. Therefore, the sheer number of expressions that would be eligible for copyright would be very, very, very many. But that itself isn't very problematic. Rather, what seems to be more problematic is if the effort expended can in some way lead to the protection of the content itself. Something that we have been understanding cannot be extended as a copyright subject matter. We will look at how the doctrine of sweater brow has been applied in some cases. Towards that front, as I explained, the seminal case on this point, originality in India, is Eastern Book Company versus D.B. Modak. In this case, there have been references to some of the most important judgments in various parts of the world. And these judgments tell us a story of how originality has evolved. I will be taking specific extracts from the judgment itself in terms of how these specific important cases have been explained, and I will attempt to explain them simply. The first case that we will look at is C. Kanhaiya versus Balraj. In this particular case, the question revolved around a drawing. The drawing itself, when it was copied by the defendant, the claim rather revolved around the originality of the subject which was drawn. As you can see here, the subject of the drawing, Balasubramanya, and according to the defendant, he said that this subject was a common subject and no copyright could be acquired by anyone on the subject. Let us do a quick recap of what we have discussed in the previous sessions. You would recall that in making a distinction between idea and expression, we have discussed that copyright extends its protection only to expressions. It does not cover the idea which is based on which an expression has been made. In fact, there could be n number of expressions on the same idea. The defendant stated that their picture was an independent production. In terms of independent creation, what the defendant is saying is that the sole consideration of copyright is that there must be independence of creation, which is that there has been no copying. But at the same time, the defendant is also saying that because the subject is so common, there is no protectable expression. The court held that in order to obtain copyright protection for literary, dramatic, musical, and artistic works, the subject dealt with need not be original, nor the ideas expressed be something novel. What is required is the expenditure of original skill or labor in execution and not originality of thought. What are we seeing here? What the court is stating is that the subject itself, which is being targeted as being a common subject, the subject itself is not originating from the author. And therefore, the subject cannot be claimed by the author at all. It is the expression which is being claimed by the author. That is the point of origin. And therefore, in the previous sessions, when we had made a distinction between copyright and novelty, and therefore, in the previous sessions, when we had made a distinction between copyright and patent, we had clearly distinguished the essential consideration of originality and novelty. Wherein, for an invention, the idea is a new idea. But the idea itself can be expressed in a number of ways. And that expression is what copyright concerns itself with. The next portion of this holding focuses on the requirement for copyright to subsist. According to the court, what is required is that there is an expenditure of skill or labor. So, according to the court, it isn't necessary that some quantum of effort must necessarily be met. Remember, we were trying to understand whether there is some level of effort that needs to be passed in order for a work to be original, or some level of skill that must be passed. You would remember that we had considered a problem there, which was if a person is skilled, then perhaps the effort that it is taking for him to create something is lesser. But does that mean that this person should not be granted copyright simply because there is less expenditure of effort? So, as the court explains, to be original, it could be a question of skill or labor, or in other words, skill or effort. And if that has been proved, then there is originality and copyright can subsist. You would see in this image a representation of an idea. And throughout our discussion on originality, you must keep in mind that copyright does not extend to originality of ideas. An original idea can be expressed in n number of original ways. And it is the originality of expression that we must concern ourselves with. The attributes which must be considered for the purpose of determining originality, as per this particular case, is skill or labor. Let us look at another case. This is Agarwal Publishing House versus Board of High School and Intermediate Education in another. The challenge posed in this particular case was against an amendment that was made by the board in its regulations. According to this, copyright of question papers set at all examinations conducted by the board would vest in the board, and it forbid the publication of such question papers without the board's permission. The question that came before the court was whether the question papers are original literary works. It was held that original literary works are not confined to the works of literature as commonly understood. After our learning in the subject matter of literary works, I am sure this is not something we need to understand anymore. It then reads, It would include all works expressed in writing, whether they have any literary merits or not. This is clear from the definition of literary work, which states that literary work includes tables and compilations. The word original, used in section 13, does not imply any originality of ideas, but merely means that the work in question should not be copied from some other work, but should originate in the author, being the product of his labor and skill. What we see here is that there is a slight change in the manner in which application of these attributes is made by the court. Instead of saying labor or skill, it says labor and skill. So, this would indicate that not just any effort would be able to pass the question of originality and the subsistence of copyright, but rather there would have to be some demonstration of a skill component. Consider the case of a photograph. As we have discussed, a skill component arises, for example, in setting up of the scene that is to be photographed. Therefore, there is a minimal expenditure of effort and a demonstration of skill. At the same time, there is a clear caution that any such question of originality must keep in mind that this is independent and not copied. Let us look at still another case on this point. This is Rai Toys Industries and others versus Munir Printing Press. The plaintiff in this case had published a tombola ticket book containing 1,500 different tickets. What is tombola? For those who don't know, it is a game in which tickets with different numbers are bought from a spinning container and small prizes are won when the numbers on the tickets are the same as the numbers on the prizes. That is what a tombola effectively. The opposite party had brought out another ticket book which the plaintiffs claimed to have written in the same year and registered as copyright. The ticket book brought out by the defendants was alleged to contain 600 different tickets, and the same had been copied identically from the books of the plaintiff. What was the question before the court? Whether the ticket books in the form of tables constitute literary work and whether copyright has been violated. Now, it was held by the High Court that preparation of tickets and placing them in tables required a good deal of skill and labor and would thus satisfy the test of being original literary work. It was recognized that the arrangement of numbers is individual work of a person who prepares it. It bears his individuality and long hours of labor. It is not information which could be picked up by all and sundry. You see what the doctrine of Brough application effectively does. If applied in the sense of effort and even with the combination of skill, it can go beyond the boundary of copyright in including the content that is a part of that expression. As you can see, the court provides this indication when it says the information itself could not be picked up by all. But is information in itself copyrightable? Therefore, what is the doctrine of Sweater-Broad doing? Its application seems to be making copyright protection extend to those items which it was not made to protect. Therefore, should a different line of test be applied? Should the doctrine of Sweater-Broad be modified or done away with to bring in perhaps a new test? What if this test is based on creativity? This is the background of Feist publications versus rural telephone service. A very important case in the evolution of originality in copyright law. Let us look at some brief facts before we arrive at the holding by the court. Rural Telephone Service Company published a typical telephone directory consisting of white pages and yellow pages. The white pages list in alphabetical order the names of rural subscribers together with their towns and telephone numbers. The yellow pages list rural's business subscribers alphabetically by category and feature classified advertisements of various sizes. To obtain white pages listings for its area-wide directory, Feist Publications approached different telephone companies operating in Northwest Kansas and offered to pay for the right to use their white page listings. Rural Telephone refused. Unable to license Rural's white page listings, Feist used them without Rural's consent. Rural sued them for copyright infringement, taking the position that Feist, in compiling its own directory, could not use the information contained in Rural's white pages. Rural asserted that Feist's employees were obliged to travel door to door or conduct a telephone survey to discover the same information for themselves. Feist responded that such efforts were economically impractical and in any event unnecessary because the information copied was beyond the scope of copyright protection. From this fact situation itself, I am sure that most of you must be in a position to say that the claim made by Rural was going beyond the domain of expression. What Rural was claiming was a copyright over the information itself. They were connecting the effort that was taken in collecting this information, in protecting the information itself, which, as Feist argues, is not within the scope of copyright protection. What the US Supreme Court is saying, we must look at very carefully. The court is saying that the most essential aspect of copyright is originality. To qualify for copyright protection, a work must be original to the author. Original, as the term is used in copyright, means only that the work was independently created by the author as opposed to copied from other works, and that it possesses at least some minimal degree of creativity. You can see here that a new consideration or an added consideration beyond the mere application of doctrine of sweat of brow has been brought in by the US Supreme Court. And this consideration is a consideration of creativity. According to the court, what is the threshold of creativity? It is a minimal degree of creativity. According to the court, such is the low threshold of creativity that even a slight amount will suffice. Therefore, vast majority of works will meet this grade quite easily, as they would possess some creative spark. Originality, according to the court, does not signify novelty. A work may be original even though it closely resembles other works, so long as the similarity is fortuitous, not the result of copy. The court further held that no one can claim originality as to the facts. This is because facts do not owe their origin to an act of authorship. The distinction is one between creation and discovery. The first person to find and report a particular fact has not created the fact. He or she has merely discovered its existence. Factual compilations, on the other hand, may possess requisite originality. What we have been seeing in the previous sessions, you can see the Supreme Court of US has very clearly stated that the underlying event or the underlying fact on which the expression is based cannot be tied to the author in terms of its origination, and therefore it is not something copyright can protect. In fact, if at all such facts had to be protected, it would not be within the domain of copyright, but if it related, for example, to some kind of a functionality, then another domain of intellectual property could protect it, which is patents. In terms of compilations, we have understood that the selection and arrangement and the manner of such selection arrangement can lead to a construct of originality. The court explains the compilation author typically chooses which facts to include, in what order to place them, and how to arrange the collected data so that they may be used effectively by readers. These choices as to selection and arrangement, so long as they are made independently by the compiler and entail a minimal degree of creativity, are sufficiently original. Thus, if the compilation author clothes facts with an original collocation of words, he or she may be able to claim a copyright in this written expression. The primary objective, according to the court, of copyright is not to reward the labor of authors, but to promote the progress of science and useful arts. In saying so, the US Supreme Court is referring to the constitutional mandate of US, wherein the mandate promotes the progress of science and useful arts. To this end, copyright assures authors the right to their original expression, but encourages others to build freely upon the ideas and information conveyed by a work. Only the compiler's selection and arrangement may be protected. However, raw facts may be copied at will. The court rejected the doctrine of sweat of brow, as this doctrine had numerous flaws. The most glaring being that it extended copyright protection in a compilation beyond selection and arrangement the compiler's original contributions to the facts themselves. A subsequent compiler was not entitled to take one word of information previously published, but rather had to independently work out the matter for himself so as to arrive at the same result from the same common sources of information. Sweat of the brow thereby eschewed the most fundamental axiom of copyright law that no one may copyright facts or ideas. The sweat of the brow doctrine flouted basic copyright principles and it creates a monopoly in public domain without the necessary justification of protecting and encouraging the creation of writings by authors. Therefore, it must be very clear to all of us now that in terms of what the US Supreme Court says is original, extends to expressions only, and such a consideration is not just based on a consideration of effort expended and the skill that has been required for it, but rather a minimal degree of creativity. With that, we will take this discussion forward in the next discussion, wherein we will take a look at how certain other courts have considered originality and its application. Thank you for joining me. I will see you in the next session. Thank you.